Hello, everyone. This is your girl, Lady D. Happy Sunday to you all. I hope you guys are having a good day so far. I just wanted to hop on quickly. I have an update regarding R. Kelly's case here in Chicago. I found out today that Jennifer Bonjean filed a reply to Darrell McDavid's response to R. Kelly's motion for severance. And I just wanted to share that with you guys. I do have a copy of the motion, and I'm going to read it to you guys. Now comes defendant Robert S. Kelly, by and through his counsel, Jennifer Bonjean and Ashley Cohen of the Bonjean Law Group. You guys know Ashley recently joined the team. Yay, Ashley! And files this reply to co-defendant McDavid's response to Kelly's motion for severance. Number one, although McDavid takes no position on severance, he found it necessary to file an emotional 13-page response to Kelly's motion to sever, seemingly for no other purpose than to protect the legacy of Ed Jensen and feign incredulity at Kelly's legitimate concern. At Kelly's legitimate concern about Mr. Glasman' potential conflict and its implications on a joint trial. Number two, McDavid's filing does not warrant much of a response, but several points must be made considering the histrionics. The histrionics. Tell him, Jennifer. Number three, first, McDavid accuses Kelly of advancing falsehoods for the purpose of circumventing the court's denial of Kelly's motion for continuance. McDavid can point to exactly zero falsehoods in Kelly's motion. McDavid's counsel is entitled to have a different take on the record, but it does not follow that his self-serving views are true. Number four, moreover, Kelly has not renewed his motion for continuance. Kelly accepts the court's ruling, even if he disagrees with it. Presumably, McDavid understands that this court can grant severance by conducting a simultaneous severed trial, which would not require a continuance. Continuance or no continuance, undersigned counsel is going to protect Kelly's interest in a fair trial because her loyalties are with him, not deceased criminal defense lawyers, no matter how legendary. You go, girl. Number five, second, McDavid's claim that Kelly's motion to sever is pretextual to circumvent a continuance is meritless. She put that in quotes, the to circumvent a continuance is meritless. Number six, McDavid's counsel, Vadim Glasman, seems to have forgotten about the two conversations he had with undersigned counsel about the issue of severance before Kelly filed a motion for continuance. During those conversations, Mr. Glasman adamantly refused to discuss McDavid's defense, expecting undersigned counsel to, in quote, take his word, end quote, that McDavid's defense would not be antagonistic to Kelly. Undersigned counsel questioned how non-adversarial defenses would be possible, but Mr. Glasman declined to elaborate. Number seven, McDavid's counsel has no obligation to share his defense theory with undersigned counsel, but undersigned also has no obligation to blindly accept a promise of harmony when the evidence suggests the strong possibility that either or both defendants would be prejudiced by a joint trial. Number eight, furthermore, as the court knows, Kelly's prior counsel raised the possibility of severance long ago. Undersigned counsel also had conversations with counsel for co-defendant Brown about the need for severance before Kelly filed a motion for a continuance. Those conversations were productive. Any competent attorney representing Kelly, in parens, who has read the discovery in this case, in parens, would understand the risk of Kelly's co-defendants possibly being used as witnesses against him at a joint trial. Kelly would hardly be in a position to complain about it once trial commences. Number 9. Undersigned counsel also told the AUSAs assigned to this case that she was contemplating filing a motion to sever when she met them to review evidence in this case on April 19th, 2022. And of course, Kelly expressly stated in his motion for continuance that he was exploring the need to seek a severance. In short, Kelly's motion to sever is not an attempt to end run the court's ruling on his continuance motion despite McDavid's outburst. Number 10. Kelly's motion to sever is not controversial. It was raised as a possibility long ago and is unquestionably supported by the discovery record and defendant's investigation. Kelly's motion is made in good faith and McDavid knows it. Number 11. Third, McDavid seems most offended that undersigned counsel has raised a legitimate concern about Glassman's potential conflict of interest and undersigned counsel's reference to Ed Jensen's public statements verifying Kelly's claim that his attorney-client relationship continued with Jensen beyond 2008, during the period that Glassman worked for Ed Jensen. There's a footnote here, number 1. McDavid's diatribe also accuses undersigned counsel of unfairly maligning Ed Jensen. McDavid's attorney's fixation with protecting the legacy of Ed Jensen is bizarre. Ed Jensen violated his duty of loyalty to Mr. Kelly when he declared publicly in the Sun-Times that Kelly was, in quotes, guilty as hell, end quote, and that he had instructed Kelly to take libido suppression pills. Oh my God. All while Kelly was facing prosecution in numerous jurisdictions. This observation is not particularly provocative. Numerous ethics professors has commented on the egregious ethical breach. And then she has the site here and also the site, I believe, where that article was. Mr. Jensen's health issues, of which McDavid's attorneys seem have intimate knowledge, may have played a role in his lack of judgment, but that is irrelevant to the issues at hand. Kelly cited the interview to show that Jensen admitted to an ongoing attorney-client relationship with Kelly after 2008, when he boasted that he kept Kelly out of trouble for 10 years. McDavid's counsel is simply upset that the undersigned counsel has prioritized her client's interests over Jensen's reputation. You go, girl. Furthermore, contrary to McDavid's statements, undersigned counsel never claimed that the ARDC did not investigate the matter. Undersigned counsel has no idea what the ARDC did or never claimed that, or did not do, in parens, although strangely McDavid's counsel does, in parens, period. Undersigned counsel merely pointed out that the ARDC did not seem to have much of an appetite for addressing ethical breach since they did not even contact Mr. Kelly, who was the person impacted by Jensen's conduct. It's rather difficult to take any supposed ARDC investigation seriously when it did not even involve contacting Kelly to see if he wished to pursue a complaint. That's right. McDavid's attorneys seem to know far more than Kelly about the alleged ARDC investigation, which is irrelevant in any event to whether Kelly and Jensen had an attorney-client relationship that extended beyond 2008. Number 12. Kelly's claim on an ongoing attorney-client relationship is not premised on Jensen's statement to the Sun-Times reporter. Kelly himself contends that he maintained an attorney-client relationship with Jensen long after 2008, and that the relationship involved regularly consulting with Jensen about legal matters for roughly a decade after his 2008 acquittal. Here's another footnote, number 2. Since Mcdavid'S fantasizes that undersigned counsel conjured a post-2008 attorney-client relationship between Jensen and Kelly, undersigned counsel will supplement Kelly's motion with a sworn declaration from Mr. Kelly. Perhaps the court will need to conduct a hearing to get to the bottom of the issue. You go, girl. Jensen's statements merely corroborate Kelly's assertion. McDavid's suggestion that undersigned counsel fabricated this issue out of whole cloth is preposterous. Number 13. In addition to conversations with her client, undersigned counsel has read the entire EDNY record and has made it far enough in the NDIL discovery to know that Mr. Kelly has faced a constant stream of legal issues since 2008, some of which brought to Mr. Jensen for advice. Number 14. McDavid has worked himself up into a lather simply because Kelly has identified a potential conflict on the part of Glasman that could prejudice Kelly at a joint trial. Kelly's motion makes clear that if Glasman worked for Jensen, while Kelly and Jensen still had an attorney-client relationship, a potential conflict exists. Then she has a case cite here. Notably, Glasman does not deny that he worked for Jensen during 2012 and through 2018, nor does he offer any factual basis to dispute that Kelly and Jensen maintained their attorney-client relationship past 2008. Number 15. Undersigned counsel cannot get into Mr. Glasman's head and was not present for any conversations that may have occurred in the infamous law offices of Ed Jensen. But it doesn't require an ethics professor to explain that Glasman could be in a conflicted position if he is in possession of privileged communications that occurred during Kelly's attorney-client relationship with Jensen. For example, if Jensen felt at liberty to make the statements he did to a Sun-Times reporter, it is hardly to stretch that he might have shared privileged communications with his associates, including an associate who represents a co-defendant who may be antagonist to Kelly. All right, now you know that's right. Number 16. It is also a reasonable assertion that Glasman owes duty of loyalty to Kelly because Jensen's duty of loyalty is imputed to him. She cites another case here. If one member of a private law firm has a per se conflict of interest, that conflict is imputed to all other members of the law firm, regardless of whether any of those other members had any personal involvement in this conflicting representation. That's in quotes, end quotes. Number 17. McDavid's attorneys are free to argue otherwise, and the government and this court will have to decide what to do with this information. Kelly is not moving to disqualify Glossman. Kelly has identified this potential conflict as a basis for severance, nothing more. Gone, y'all. Number 18. Lastly, McDavid's vitriolic. Yeah. Lastly, McDavid's vitriolic response merely underscores the likelihood of antagonistic defenses. Undersigned counsel may not be familiar with the discovery as McDavid's counsel claims to be, but she apparently is familiar enough to file a motion to dismiss that they overlooked, in parens, and joined, okay, in paren, and to know that there is ample evidence to show that McDavid was in complete control of Kelly's finances and helped himself to the fruits of Mr. Kelly's labor. Okay? The fact that McDavid intends to vehemently deny this claim simply shows that it is possible that either or both co-defendants could suffer prejudice at a joint trial. Number 19. The government presumably has something to say about this, and the court will rule on the motion. Defendant will accept the ruling. That's how litigation works. Tell him, Jennifer. Conclusion. For the foregoing reasons, defendant respectfully asks this court to sever his trial from co-defendant McDavid's trial and further to sever counts 10 through 13 from the remainder of the indictment. Respectfully submitted. Jennifer Bonjean and Ashley Cohen. You go, ladies. Awesome reply. Awesome reply. So I just wanted to hop on quickly and share that with you guys. Please let me know what you guys think about the motion, her motion in the comments section. And I will reply as you guys make your comments. Okay? And that's all I have for you today. I just wanted to update you guys on Jennifer's reply. Take care. Talk to you guys soon. Bye-bye.